Good day. Again, guys, I am your online learning coordinator for this subject, social issues and professional practice. So for today, we will discuss the week 8 of this subject, which is we will be focusing on intellectual property rights. Okay, so these are the learning outcomes for this module. So you should be able to define intellectual property in other terms connected to it, define copyright, patents, and trademarks. So basically, we'll be focusing on these three main topics. Understand the foundations on gaining copyright and patent right. Understand the procedures on giving copyright and patent right. Understand the duration guidelines for copyright, patents, and trademarks. Lastly, you should be able to determine and understand the laws that states the information on copyright, patents, and trademarks. So these are the learning outcomes for this module. So these are the topics that we have to uncover: intellectual property, intellectual objects, copyright, patent, and trademarks. So let's start defining intellectual property. So these are tangible things such as ideas, inventions, technologies, artworks, music, and literature, and others that one can claim ownership to. So basically, any of those that we have mentioned, say for example, any book that you have, let's say, write or you have written, then that is something that you can claim ownership to. Or any, let's say, song that you have composed, then you can claim the ownership for that song that you have composed, or any artwork or any inventions like what has already been mentioned here. So intellectual property is also a set of legal rights which result from intellectual activity in the industrial, scientific, literary, and artistic fields. So basically, that's the definition of the intellectual property when we talk about the definition from the books that we can read as well. So intellectual objects has the following characteristics, such as non-tangible, non-exclusionary, no scarcity, and legal claim. So these are the intellectual objects that, or the characteristics of intellectual objects. Okay, so let's talk about the copyright. And let's define this terminology. It is the exclusive right to distribute, display, perform, or reproduce an original work in copies or to prepare derivative works based on the work. So when we talk about the intellectual property rights, there's also a specific law in the Philippines that is being implemented, and it is being called Republic Act number 8293. So part 1, section 2 of this law has this definition for the copyright. So for example, if you have written a specific book, then it's only you who should be able to, you know, allow the distribution, display, performance. So for example, if that book is something that can be performed by a group of people, then you should have the approval first as the author of that book. Okay, or even to reproduce that, you should also have the right to allow or not to allow people to reproduce the copies of those books that you will be writing, for example. So any original work, that is something that you can, of course, claim the ownership to that specific original work. And then you have the exclusive right to the following that we have mentioned. Okay. So when we talk about registration and deposit, the owner of the copyright may file an application for issuance of certificate of registration. So the COR or certificate of registration should be or you should have this in order for you to claim ownership of that original work. And deposit of copies or reproduction of the works with the Copyright Division of the National Library and the Supreme Court Library. So you should submit or deposit copies or reproduction of the original works that you are claiming that you have or that you own those original works. And you should have the certificate of registration as well. So also can be done through the Bureau of Copyright and Related Rights of the Intellectual Property Office. So that's also one thing that you can consider. All right. So these are the requirements. These are really basic requirements that you should comply. First is duly accomplished registration and deposit form. Document evidencing ownership of the copyright or the manner of its acquisition, usually in the form of an affidavit. Document evidencing identity of the applicant, special power of attorney, corporate secretary certificate of board resolution, payment of filing fee, plus 2 original copies of the work covered by copyright. So these are the requirements that you have to comply in order for you to get the certificate of registration of that original work. All right. It is stated in the Intellectual Property Code of the Philippines, or RA 8293, what are considered as original works under Section 172 and derivative works Section 173. So if you would like to read the information about this, then you may visit the specific law under these sections. You may find those things regarding the Intellectual Property Code of the Philippines. Um, and we also have the duration of copyright, like under Section 213.1 of the Intellectual Property Code, you'll be able to see the duration of, for general works. For joint authorship works, it can be found under Section 213.2. For anonymous or pseudonymous works, it can be found under Section 213.3 of the IP Code. Works of applied art, it can be found under Section 213.4 of IP Code. Photographic works and audio-visual works can be found under Section 213.5 and 213.6 of the IP Code. Sound recordings can be found under Section 215.1 of the IP Code. Broadcasts can be found under Section 215.2 of the IP Code. So when we talk about patent, by definition, protect inventions or discoveries. So any inventions or discoveries can be protected. All right. An invention or discovery is patentable if it meets 2 basic requirements, such as the invention or discovery for which the patent is sought is new and useful, or is a new and useful improvement. Second requirement is that the invention or discovery must satisfy the following 4 conditions, such as utility, novelty, non-obviousness, and disclosure. So these are the requirements in order for you to have the patent of that or those inventions or discoveries. Okay, so patent rights is the right to a patent belongs, or the right to a patent belongs to the inventor, his heirs, or assigns. When 2 or more persons have jointly made an invention, the right to the patent shall belong to them jointly. It should not belong to one of them, but it should belong to both of those inventors. If 2 or more persons have made the invention separately, this is a different case, and independently of each other, the right to the patent shall belong to the person who filed an application for such invention, to the applicant who has the earliest filing date or the earliest priority date. So whoever files the patent right, or who files it at the earliest time, then that ownership belongs to that person who has the earliest filing date. Okay, that has already been mentioned under Section 29 of the IP Code. Then Section 30 of the IP Code states that in case the employee made the invention in the course of his employment contract, the patent shall belong to the employee. If the inventive activity is not a part of his regular duties, even if the employee uses the time, facilities, and materials of the employer. So basically, even if the inventions or the invention has been made um, and the facility or the materials of the company has been used, then the ownership will still belong to the employee. If again the invention is not a part of the employee's regular duties. On the other hand, the employer will own the invention if the invention is the result of the performance of his regularly assigned duties. So if you have signed any contract with that employer, then the employer will own the invention that you have developed. Okay. So it must have the following requirements, such as request for the grant. Okay, request for the grant of patent, description of the invention, drawings, if any, claims, and abstract. Okay, and duration of this or duration of patents is 20 years from the filing date of the application. There's also what we call cancellation. Any interested person may file a petition to cancel the patent or any claim thereof or parts of the claim on any of the following grounds, such as lack of novelty, the patent fails to disclose the invention in a manner sufficiently clear and complete for it to be carried out by a person skilled in the art. The patent is contrary to public order morality. So that is indicated under Section 61 of the IP code. And there's also what we call limitations of the patent right. The owner of patent has no right to prevent third parties from using the invention under the following circumstances. What are those? Patent to market, private and non-commercial purpose, experiment purposes, individual cases, used in a vehicle. So these are the circumstances that the owner of the patent has no right to prevent other people or third parties from using his or her invention. Okay? And then when we talk about trademark, it refers any visible sign designated as such in an application for registration and capable of distinguishing the origin or any other common characteristic. So trademark basically, guys, is something that can be registered by, let's say, for example, a company or an individual person that he or she created that trademark, let's say the logo of a certain company. If you're seeing, let's say, TM, that stands for trademark, that means that that logo is registered and owned by, say, for example, a company or an individual person. There's also another, if you can see the small r on that logo or on a logo, then that states that the logo or that trademark is registered to a certain or with a certain company or an individual. Okay. And then the duration for this is still 10 years. The registrant is required to file a declaration of actual use with proof of such use within 1 year from the 5th anniversary of the date of the registration of the mark. Otherwise, the mark shall be removed from the trademark registered by the Intellectual Property Office. A trademark registration may be renewed for periods of 10 years after the expiration of the original 10-year term upon payment of the prescribed fee and upon filing of a petition for renewal of registration. So that's the duration or validity of trademarks. And basically, guys, that's the end of the discussion for this module. I hope that you were able to understand the topics that we have discussed, and I'm looking forward to see each and every one of you again on the next meeting that we will have. Thank you so much for listening and keep safe always.